My name is Kaj Rozga. I'm an antitrust lawyer at Wright Tremaine. I want to thank you for joining the AHLA Antitrust Practice Group's latest video update. Today, I will be discussing the ongoing trial in Sidibe versus Sutter Health. This is truly a landmark healthcare antitrust litigation. It concerns contracting practices of Sutter, which is an integrated health system, and its dealings with insurers. And it's a rare opportunity to see what happens when these sort of antitrust theories go before a jury. That's one reason I'm really excited to talk about this trial and cover it. And the other interesting aspect about the case, for those that haven't had a chance to follow along, are the plaintiffs that are bringing it. So it's not a case brought by insurers who would be sort of most proximately impacted, when it comes to negotiations between providers and insurers. But instead, it's brought on behalf of insurers' subscribers who are impacted indirectly to the effect that they are contracting with the insurer to get access to the insurer's health plan network. So it's really been styled as a consumer class action, which was unusual at the time that this case was filed. In this instance, it includes a class that represents 3 million insurance subscribers who are patients of Sutter Health. And that includes individuals who used insurance, but also employers who covered insurance that's offered to their employees and subsidized for their employees. So the case has a long history. It was filed a decade ago. It was actually dismissed right out of the gate before the Ninth Circuit reversed and brought the case back. Discovery closed already 5 years ago, but the trial only started just now on February 10th. We had opening arguments in the case, and it's expected to go on for 4 weeks. So I'm going to briefly explain what the plaintiff's claims are about, and then we'll get into sort of what sort of themes the Sutter Health has been developing in the course of the first week and a half here of trial. And the plaintiff's claims are basically that there's a market where hospitals compete with each other to be included in network in insurance health plans. And in that market, essentially, insurers are stepping into the shoes of their subscribers, who are the actual patients that will go to a provider's facilities. And the plaintiffs in this case claim that in some Northern California localities, Sutter Health is essentially a dominant hospital. But in other localities, they say Sutter is not as significant a player and faces more competition from other providers, from other hospitals. And of course, there's nothing unlawful about Sutter Health achieving a strong market position. But what plaintiffs allege is anti-competitive, where they allege there are antitrust violations, is in the nature of Sutter Health's contracting with certain insurers in the market. And in particular, they focus on two aspects of those negotiations. The first, the plaintiffs allege that Sutter has or had required all or nothing contracting with insurers. And what that means is Sutter is a health system with over 20 hospitals. And the plaintiffs allege in the case that what Sutter demanded from the insurers is that if the insurer wanted to contract with any one of those hospitals, they had to contract with all of them. They had to have all of them in the network or none of them in the network. That's this sort of all or none phrasing. And the effect of that approach is that the plaintiffs allege this has tied insurers' access to the hospitals in those more competitive markets to access in the hospitals in the less competitive ones. And then the second part of the plaintiff's allegation is that Sutter required anti-steering provisions in their contracts with insurers, and that these anti-steering provisions essentially prevented insurers from directing their patients or their subscribers to lower cost providers, which is a common tool that insurers might use to try to direct their subscribers away from one provider to another based on the cost that provider imposes on the insurer. So the combined effect of these contracting practices, according to the plaintiffs in the case, is that insurers were unable to pick and choose which Sutter hospital they wanted in network. and they could not encourage their subscribers to use one hospital over another. And in both of these regards, the plaintiffs say that this made it difficult for insurers to direct their subscribers to lower cost providers or to create health plan networks in the market that were lower cost. So the allegation is that this inflated the cost to the insurers, and that the insurers, remember, the insurers are not the plaintiffs in this case, it's the insurers' subscribers who are the plaintiffs. So the allegation is further that the higher costs that are alleged to have been imposed on the insurers were then passed on to their subscribers through higher premiums or higher cost sharing. And so in the end, the plaintiffs allege over $400 million in damages from such inflated costs. And that's the basis for alleging a state antitrust violation under the California state antitrust statute, which essentially is an allegation that's similar to a unreasonable restraint of trade allegation under Section 1 of the Sherman Act. So the first 2 weeks of trial, or approaching 2 weeks of trial, has seen quite a few Sutter executives testifying. Some insurers from Northern California also have testified, as well as some employers or class members or plaintiffs in the case. And the plaintiff's case in chief has generally been hitting on their key themes. Those being, one, that Sutter Health is a sort of must-have. It has must-have facilities in certain localities. That those facilities have higher rates that they charge to insurers. That Sutter's facilities don't offer the same or don't offer a higher level of quality of care than other hospitals. And moreover, they have been trying to draw out evidence that insurers requested that Sutter allow them to have certain Sutter hospitals in network and not others, essentially offering tiered networking, which is a health plan product that would cause subscribers to have incentives to go to certain providers who are in different tiers based on the cost that they impose on the insurer. So the evidence has been trying to show that the insurers sought those sorts of provisions, but that Sutter declined it. And that this meant that the insurers were unable to offer lower cost, narrow network products in the market. Although it's really been the plaintiff's case in chief, Sutter has been able to use those same witnesses to develop its own defense themes. So they've argued through the same witnesses. First of all, they've argued that Sutter, or tried to show through the evidence, that Sutter does not have market power in these areas. In particular, pointing to a rival, Kaj Rozga, another major health system in Northern California. They've also sought to elicit testimony showing that the contracts that Sutter entered into with payers don't actually compel system-wide contracting, but rather they offer discounted rates for doing system-wide contracting. Additionally, they've elicited testimony to try to show that this sort of contracting practices are intended to help achieve integrated care. So that's an argument that this improves quality of care at the facilities. And finally, they've some of the themes that they've been developing and made in opening arguments are not strictly legal defenses, but they are definitely ones that I think will are targeted at the jury, trying to think about what the context is of the behavior here. And there, I would just sort of point to three particular areas that Sutter has been trying to develop in the record. First, they've been making clear that Sutter Health is a non-for-profit and that it needs to reinvest, or that it's required to reinvest its gains back into the system to the benefit of patients. Two, that Sutter Health takes on a lot of government-sponsored patients and has a lot of charity care, and that they need to offset those losses through revenue and patient flows from commercial insurers. And three, there's been, in the opening arguments, there was some reference to the fact that this case is really sort of an insurer case, and that the subscribers are the vehicle for really what is a case brought by an insurer. And I think there, the point or the signal to the jury is that, what you have here are two behemoths really sort of duking it out in a negotiation. And so, they should be sort of left to the market forces that would play out in those negotiations. So I think it's a really interesting case. I'll be looking over the next 2 weeks here to see how the jury deals with the complexity of the healthcare markets. Who are they going to be sort of more sympathetic to? The provider of care or the insurers, who are really sort of their proxies in the negotiations with providers? I'll be interested to see how Sutter further develops the sort of nonprofit charity care aspect of the story here, and whether the jury will be swayed by that. And finally, whether the jury ultimately sort of sees this as hard-nosed negotiation tactics, that are business as usual, or whether the notion of that occurring in the healthcare market might, whether that impacts the jury in some way. This is not something we typically get to see layperson jurors weigh in on. And so it'll be interesting to see how these themes sort of resonate with the jurors. So that's it for this sort of quick initial update, try to frame the case, give you an idea of what the case is about. Come back next time. We're going to have another follow-up episode, and we'll sort of talk more about what testimony actually came out during the trial, and what kind of big takeaways there might be for healthcare professionals. So thank you for watching this initial update, and I look forward to coming back for the follow-up. Thanks again.